Welcome to Ben Franklin's World, a podcast about early American history with Liz Covart. The study of history is key to understanding who we are and how we can affect a better future. Ben Franklin's World will introduce you to historical people and events that have impacted and shaped our present-day world. And now, here's your host, Liz Covart.
Hello, and welcome to episode 69 of Ben Franklin's World, the podcast dedicated to helping you learn more about how the people and events of our early American past have shaped the present-day world we live in. For many 17th century Europeans, law and order stood as a sign of civilization, which is why some of the first European settlers in North America looked to impose systems of law and order in their new homeland. Today, we explore aspects of the law and order the colonists imposed by exploring the early legal systems of colonial New England. With the help of Abby Chandler, an assistant professor of history at the University of Massachusetts Lowell, we're going to conduct our investigation into early New English legal customs using sexual misconduct cases. During our investigation, Abby reveals why sexual misconduct cases are ideal for looking at changes in early American legal history, how colonists in New England used their legal systems to become more English, and details about sexual misconduct charges, trials, and punishments. But first, have you told anyone about Ben Franklin's World lately? Word of mouth recommendations are the best way for people to discover new podcasts. Please help the show and your fellow history lovers out by telling them about Ben Franklin's World. I assure you that not only will I appreciate this action, but everyone you tell will appreciate it too. Okay, are you ready to discover more about early American legal history? Let's go meet our guide.
With tidings and wisdom to share about our early American past, here is this week's special guest.
Our guest is an assistant professor of early American history at the University of Massachusetts Lowell. Her research interests include legal history, medieval European history, and British imperial history. She has published 3 articles and her first book, Law and Sexual Misconduct in New England, 1650 to 1750. Welcome to Ben Franklin's World, Abby Chandler.
Thank you very much, Liz.
I have introduced many early American historians on this show, but Abby, medieval European history? Not many early American historians have this background. So would you tell us about your interest and how it helps you research and interpret early American history?
Well, some of the credit for that actually should be given to a high school history teacher of mine who hated textbooks and had us only read primary source documents in translation where needed. And so that, when I was 14, gave me this interest in medieval European history that evolved over time. I eventually did become an early Americanist, but in order to understand how law changed over time in the colonies, it struck me that I also needed to know how law had evolved over time prior to that. So this is what led me to have a field in medieval European history. And that was actually, when I was working on my PhD, one of my core fields, which is, as you say, rare for Americanists, but it's a background I found very helpful over the years.
When you say primary source documents, what types of records are you talking about?
Well, there's such a wide range of defining that, and this is something I talk a lot about with my students when I'm teaching. For me, the core documents that I use are court records, but letters written at a time period, political treaties, newspapers, wills, anything like that often is counted as a primary source document.
So it's really anything written at the time period that you're studying?
Yes. Although the issue of memoirs, someone like Mary Jemison, who was taken captive in the 1750s, but who didn't compose a memoir of her life until much later in the early 1800s, raises this question, is it a primary source document because she's talking about things that happened 50 years ago? And so there is always that question of, does it have to be composed at the time it happened, or is it just enough to have it be the person it did happen to?
Those are interesting questions and ones that historians must grapple with.
Yes, all the time.
Let's transition to your book. In Law and Sexual Misconduct in New England, Abby sets out to show how the colonists in New England became more English, at least in their legal system, through the 17th through the 18th centuries. Now, Abby, the colonists who settled in New England were English. Would you tell us how it was possible for them to become more English, especially as they'd lived away from England in North America for such a long time?
This idea that the English colonies in North America were becoming more English over time is one that really was first introduced to people who study early American history by John Murren, who had a dissertation in the 1960s making this argument. And he focused in particular on Massachusetts, which starts out trying to get as far away from England as possible in their law, in their religion, but over time will become more English at the turn of the 18th century. A lot of their reasoning for doing that was, at this point in time, England was starting to have more and more control over what it was their colonies in North America were doing. So in many cases, Massachusetts' transition towards a more English legal system was as much about demands from higher up. That said, what has always fascinated me as a person who's lived in New England for a lot of my life, a person who studied New England for a lot of my life, is the enormous disparities between the individual New England colonies. So if Massachusetts has to do this transition to becoming more English, colonies like New Hampshire, Maine, Rhode Island, when they first got going in the 1600s, were colonies who were comfortable, much more comfortable with their English origins, and so consequently begin as having a much more anglicized legal system and will maintain that, although Maine goes through a period where they get taken over by Massachusetts in the mid-1600s, where they have to move away from England and then steer back again in their legal system as Massachusetts did.
When you say New England, what do you mean? Because today we classify 6 states as belonging to the region of New England. But when the English established this region, there weren't 6 colonies, and the colonies that did form were very different from the states we know today.
And that's, again, one of the great joys of studying this very small region. You have Plymouth Colony, you have Massachusetts Bay Colony, there's New Haven Colony, there's what will become Connecticut Colony, but Plymouth and Massachusetts will eventually merge. The Connecticut colonies will merge together. Maine is originally founded as multiple little colonies that will eventually get taken over by Massachusetts. New Hampshire is founded as an independent colony, manages to remain one. Rhode Island is founded as an independent colony, manages to remain one. And then, of course, Vermont begins to come into the picture in the 1750s and up through the American Revolution.
How were these colonies established? Were they all Puritan colonies?
They weren't. And this, again, is something that I really love with looking at this early colonial period. Massachusetts and the Connecticut colonies are definitely founded by the Puritans. Plymouth is founded by the group often known as the Separatists, who, like the Puritans, are concerned about the English church, but do some variations on that. New Hampshire and Maine are mostly founded originally by Anglicans, but you do also see other religions thriving there. Rhode Island, of course, is founded by Roger Williams, who's sometimes called a Baptist. Over time, Rhode Island's commitment to religious tolerance will lead to, again, a very wide range of religions coming to live in that particular colony. So yes, we have the core Puritan colonies, but then we also have the non-Puritan colonies.
It seems with the differences in the way these colonies were established, there must have been differences in their legal systems, which is what you study. Would you tell us about the legal systems in New England that you studied?
My book in particular focused on Essex County in Massachusetts, on what was originally known as the province of Maine, and on Rhode Island. When I was doing my original dissertation research, I also looked at Plymouth Colony and New Hampshire. So if this book doesn't particularly deal with them, I do have the knowledge of what happened in those particular colonies. And for all that Massachusetts and Maine are different in the sense that one is a Puritan colony, one is a non-Puritan colony, their court systems are relatively similar. And actually, both of them are modeled very much on the rural English tradition, where you have a court system and whoever is your justice is usually the most prominent man in that particular community. He might have a background in the law. He might not have a background in the law. And those are usually quarterly court systems, which, again, is a very English idea. In both Rhode Island and Plymouth colonies, the idea of having a specific set of justices is not something they do as much of. For a very long time in both Rhode Island and in Plymouth, the men who served in the colony legislature also served as the justices. Why Plymouth did it that way, I'm not quite certain of. It may have just been lack of people to go around. For Rhode Island, I think the reason why they aren't creating a separate justice class is because in Rhode Island, there may not be the development of a specific justice class, but there's definitely the development of a specific attorney class.
Why did you decide to chart the Anglicization of the New English legal system through sexual misconduct cases in particular? It seems like there must have been a lot of different court cases that you could have chosen for your study, but you chose sexual misconduct cases.
Yes, there definitely are a wide variety of court cases. In choosing sexual misconduct trials, it had as much with looking at the wider body of literature on the Anglicization of the British colonies in North America. There have been many books written about that. But what struck me about most of them is that they were looking at this as a top-down process. You have people in England saying, you will do this, and the colonies do or don't do this. But what really interested me as a historian was, well, what did this feel like as an ordinary colonist on the ground? And sexual misconduct was something that was consistently tried in all of the New England colonies over the period of the 17th and 18th centuries. And it was also a crime that men are consistently tried for, women are consistently tried for. And so it gave me a body of evidence in which I could use to track change over time for that 100-year time period of the book, but also really begin to examine the question, well, if your legal system is more anglicized, how do these laws affect you as an ordinary colonist? Does it affect men and women differently? And so that was why I came up with that idea of that particular source base.
How much of a problem is sexual misconduct in early New England? Because when we stop to think about it, many of us have this image of Puritans as these conservative, religious people where sexual misconduct wouldn't seem like a problem in that community.
It's one of those things, and Elsa Hamilton has also grappled with this question. How many people are we actually talking about? And it's very hard to find a court session in the 17th and early 18th centuries in New England that doesn't have at least one person on trial for sexual misconduct. Nevertheless, when you take those numbers against the wider numbers of colonists, it looks like something that, if they're always putting people on trial for it, it's still a relatively small part of the population. So it's on people's minds, but most people appear to either be following the social norms or just not getting caught. And that's always the problem with working with court records. You only have the records of the people who actually got put on trial.
Yeah, what kind of records are left, and how did those records define sexual misconduct? Like, when we're talking about sexual misconduct, what are people being accused of?
Most of the trials that I worked with were very ordinary. This is the trying of people for any form of sexual contact outside the marriage bed. So if you were a couple who was engaged and were having sex and then got married, and the wife gave birth to a child 2, 3, 4, 5, 6, 7 months after the marriage, that couple would be put on trial for fornication before marriage charges. If you are a couple who are having sex and you conceive a child and don't marry, then you will be put on trial. Generally, women are tried for bastardy, men are tried for paternity, and I can talk more about those distinctions later. Other types of trials that I found, and these are quite rare, there's the occasional rape trial, there's the occasional incest trial. even more rarely, there's the occasional bestiality trial.
How are these trials conducted, and what sorts of evidence are the people on trial asked to muster?
These are, again, trials taking place in the quarterly court system. So 4 times a year, the court is held. If you have been accused of this particular crime, you're expected to turn up at court, usually the next court trial that's being held. That said, in all of my jurisdictions, I did occasionally find petitions from someone saying, yes, I recognize I'm on trial. I can't make it to court on that day. Could I come to court the following session? And those universally seem to have been granted. So there's, I think, a recognition that getting to court can be a challenge for people in this time period. And usually there'd be a great deal of preparatory work done before the court trial in which the justice, when you're working with the colonies who have placed most of their emphasis on the justice, is going to be doing some work to collect depositions, collect statements, collect evidence. And the one really important thing to keep in mind with that, and this is true across the board in the New England colonies, is if you are put on trial and you are acquitted, you are responsible for paying court costs. So if you are guilty and you know you're guilty and you know there is absolutely no chance that you're going to get out of this, it is actually in your best interest to not have a justice or a sheriff going around collecting depositions, because that justice or that sheriff is going to charge you for the costs of collecting those depositions. So this creates particularly in Essex County, a body largely of bastardy and paternity trials, which are very well documented. In those cases, these are either families who are spending the money for the depositions in the hopes of getting their sons who've been accused of getting women pregnant acquitted, or in the case of pregnant women, their families are trying to make certain that the man that she is accusing of getting her pregnant will be convicted and then responsible for child support. So if in some ways this is a court trial process that is familiar to us, the idea of collecting evidence, eventually holding the trial, that makes perfect sense to us. The idea that you might deliberately avoid having statements taken because you don't want to pay for them, because you're fairly certain you're going to be convicted, that to us today is a much stranger system.
One thing that I find curious in the way you describe this process is it doesn't sound like there are any lawyers involved. It's the people on trial go out to collect the evidence. They go out and pay things. They present their case. Doesn't early New England have lawyers?
Well, it depends entirely on where you are. The Massachusetts Puritans have very firm opinions about lawyers. They do not approve of them, and consequently, for a very long time in Massachusetts, it was illegal to receive money for offering any form of legal counsel. That said, in Massachusetts, justices are encouraged to have these positions where they're one part justice in the courtroom, but one part legal counsel. If you were in trouble, you were encouraged to go to your local justice and ask his advice prior to the trial, and I found several cases like that in Essex County. That said, Rhode Island had no issue with attorneys. I found attorneys involved in sexual misconduct trials in Rhode Island for the duration of the time period I studied. When I was doing my dissertation research, I found attorneys in New Hampshire also involved in sexual misconduct trials. And Maine, which again starts as an independent colony, is taken over by Massachusetts, but then Massachusetts comes more in line with England. I found attorneys in Maine before the Massachusetts takeover, and then as Massachusetts is becoming more anglicized, it becomes legal to have attorneys in Massachusetts, and so the attorneys reappear in Maine. So yeah, whether or not you have an attorney entirely is connected to where it is you live in this particular region.
Do the justices who are hearing these cases have an edge? Do they have any sort of formal legal training?
Almost none of them had formal legal training. However, there was a recognition that if you were going to have this position, it is incumbent upon you to be as familiar with the law as you can. And one of the most popular legal books in England and in the North American colonies at this point in time was a book that's popularly known as The Country Justice, which was written by Michael Dalton. And as I often tell my students, it's how to run a courtroom for dummies, because it's alphabetized and it goes through. If you're putting someone on trial for this, then you do this. If you're putting on someone on trial for this, then you do this. And at the back of the Country Justice, there are actually forms that you could fill out so that you could fill out a warrant form and then copy that over and over and over and over again to use it. So if most of these justices don't have formal legal training, they seem to have gone to a certain amount of effort to acquaint themselves with the law as they could. And we know that when Charles Frost, who was a justice and from a family of justices in Maine, died, an probate inventory was done, and he had over 150 pounds worth of legal texts in his library.
Are the justices the people who made decisions in these sexual misconduct cases, or did juries of the defendants' peers determine guilt or innocence?
Again, you're entirely dependent on where you are in New England. English law at that time period allows for the option of having a jury to hear your trial. One of the disparities I found is that Rhode Island both says it is legal to have a jury to hear your trial, and you have the option of asking for a jury to hear your trial. And there are actually several sexual misconduct trials from Rhode Island in which they appeal to the jury then hears it. In the other New England colonies, it was legal to ask for a jury, but I get the sense that there was some pressure on colonists not to do that, because the only sexual misconduct trials which involve juries are also the rape and the incest trials, the ones where the stakes are that much harder. Technically speaking, under English law of that time period, Massachusetts law of that time period, if you were convicted on rape charges, you could be hanged. Now, they almost never did that, but I think there's an understanding if those are the stakes, then by all means, you need to have a jury, you need to have a second opinion.
Many of the sexual misconduct cases that Abby follows in Law and Sexual Misconduct in New England comprised issues of premarital sex and paternity. Abby, these appear to be he said, she said cases. What evidence did the parties involved in these cases have to muster or present to prove their case?
Unfortunately for women, it's almost impossible not to be accused and tried and convicted. If you are pregnant and you are not married, the evidence is right there in your body. For men, it's a much more complicated thing because it comes down to confession. If the man stands there in court and says, yes, I am responsible, I did indeed have sex with her, I did indeed make her pregnant, well, that's easy, you can convict him. The problem, of course, is what do you do when the man will not confess? And here the colonies in Massachusetts and in Maine to some extent, and I also tracked this in Plymouth, relied on a much older European tradition where when the unwed mother is giving birth, she is required to be asked by her midwife over and over and over again during her labor pains who the father of her child was. And what I tracked over the course of my research is 99.9% of the time, if a woman consistently named the same man as father of her child throughout the birth, her midwife would then testify, she said this is who it is, and she kept it up for 10 hours when she's in agonizing pain, and that man would then be convicted. In Rhode Island and periodically in Maine, there's less emphasis placed on midwife testimony, and there's a greater emphasis placed on the woman being asked to accuse the man who she is saying has gotten her pregnant in a crowded courtroom in front of all witnesses. So that's as much about theater as it is about law.
I guess it makes sense that you'd see a tradition like the midwife asking the birthing mother over and over who the father of your child was, just because childbirth is like the number one cause of death for women in early America, right?
And that was an enormous part of it, this idea that, well, you could die. You're probably not going to lie when you're potentially on your deathbed. And one thing I found interesting is that I've worked with so many hundreds of these trials, I only ever found one case in which the woman actually did die in childbirth. And it's a very well-documented trial. Mary Town in Topsfield, Massachusetts, is giving birth. She's accusing her cousin Benjamin Town of getting her pregnant. And when her family realizes, and her midwife realizes, she will not survive, they call in the local minister. And this is one of the most heartbreaking documents I've ever worked with, because the poor girl, who was only 17 or 18, had to have been in agonizing pain, and yet she has a minister saying, "Are you telling us the truth? Are you telling us the truth? Did Benjamin Town father your child? Because if you lie about this, you're going to die in 30 seconds," or whatever it is. And she continues to accuse him right up to her dying breath while simultaneously apologizing for her transgressions and her wrongs. So that seems to have been something they took very seriously.
What was the punishment for men and women who were found guilty of sexual misconduct?
That is something that evolves over time and also varies a bit between the individual jurisdictions. When we think about somebody punished for sexual misconduct in New England, the first thing that comes to most people's minds is Hester Prynne and her Scarlet Letter. And one of the things I noticed was that kind of very public punishment is done in the very early years. I found people being ordered to wear a B for bod. I found somebody ordered to stand up in front of the whole community in a white sheet. But over time, those punishments disappear. By the time you get to the mid to late 17th century, generally the punishment is asking you to be fined or whipped. However, in 1668, Massachusetts adds a variation on this. Up until 1668, men and women were punished equally. However, in 1668, Massachusetts, who's concerned about rising numbers of illegitimate children, introduces a new law where women who had illegitimate children would be convicted on fornication and bastardy charges, given a choice between a fine or a whipping, as they always had been. Men, by contrast, would now be tried on paternity charges and would only be responsible for paying child support costs. However, if you were a couple who was convicted on fornication before marriage, the couple would continue to be fined or whipped with no distinctions drawn. That said, other variations, as I got deeper and deeper into Massachusetts, the decision is made, at least in Essex County, probably in the other Massachusetts jurisdictions, to start to phase out whipping, so that by the 1700s, people are only being fined. They barely whip anyone after a certain point. Maine and Rhode Island will continue giving you the choice between being fined or being whipped right up through the end of the time period I studied. And I think the reason why Massachusetts makes this decision is Massachusetts has a very wide legal infrastructure. Fines are more useful for paying for that particular legal infrastructure. Maine, in particular, is a much more rural place. There's less money on hand, and so whipping was helpful to have as a punishment for somebody who couldn't come up with the money for the fine. And why Rhode Island keeps doing giving people the choice is unclear from their culture.
Some of us had to read Nathaniel Hawthorne's Scarlet Letter. Any instances of the Scarlet Letter and Hester Prynne-like punishments?
Well, as I mentioned a little while ago, there was a B for bod that I found. I forget which jurisdiction that was. There's a woman in the early 1600s in Maine who's told to wear a white sheet into church. But on the whole, Hester Prynne seems to have been a fairly unique thing. The other thing that strikes me most about Hester is it's not just that she has to wear the Scarlet A, it's that she's ostracized for decades afterwards. Whereas by contrast, the sense I have is that people who are put on trial for sexual misconduct trials are reabsorbed into their communities relatively quickly. And it seems as if there's this idea that if you own up to your sins, you take your punishment, then over time your life will go back to normal. And the other thing to keep in mind is you have people from all walks of society who are put on trial. One of my favorite sequences is in the main court records. The Preble family are very prominent. There nearly always is a Preble who is a justice, and you have multiple generations of the family in which Mr. and Mrs. Preble were tried for fornication before marriage, and then 20 years later, Mr. Preble shows up in the court records who is escorting his daughter to court because she's just been accused of fornication outside of marriage, and the fact that this very socially prominent family could be put on trial for this but carry on being socially prominent says something about how this is not something that will destroy the rest of your life.
Now that we have an idea of how these trials worked and what people were being tried for, could we look at one of the cases you cover in Law and Sexual Misconduct in New England in bigger detail? Perhaps maybe the case of Elizabeth Sessions and Joseph Chandler, or maybe Deborah Proctor's daughter.
I will talk about Elizabeth Sessions and Joseph Chandler, and for anyone who noticed the similarity, yes, Joseph is one of my ancestors. I was actually rather grateful when I found this trial because if anybody ever accused me of talking about their ancestors' sexual doings, I could point out I do the same to my own family. This is a trial that I found particularly fascinating because it really comes down to this issue. How do you prove which man fathered the child? Elizabeth Sessions in 1691 in Andover, Massachusetts, was in an unfortunate position. Her father had died a few years earlier. There wasn't enough money to keep the family home together. She originally was a servant in the household of Hannah Chandler Bixby, Joseph Chandler's older sister. It's unclear exactly what happened, but Elizabeth appears to have been kicked out of the employment of Hannah Chandler Bixby and her husband Daniel and has gone on and is now working as a servant in the Christopher Osgood household. While Elizabeth is a servant in the Christopher Osgood household, it becomes evident that she's pregnant. And Nathaniel Saltonstall, the local justice, comes and interviews Elizabeth and asks who the father of her child is. And Elizabeth accuses Joseph, implies that it was rape. It's very hard to tell. And so the normal course of the trial begins with Elizabeth saying, yes, it was Joseph, and the Nathaniel Saltonstall says to Joseph, well, did you do this? Joseph says, no, I didn't. And again, I'd mentioned earlier that you tend to only find lots of depositions in trials with families who are willing to pay for them. Well, the Chandler family jumps into action, and there's deposition after deposition after deposition from members of the Chandler family, friends of the Chandler family, saying, well, Joseph can't be the father of Elizabeth's child because we saw Elizabeth out in the backyard at 3 a.m. with John Russ. And John Russ's family, and Russ, by the way, is a nephew to Christopher Osgood, whose household Elizabeth is a servant in. So the Russes and the Osgoods jump in, and there's a series of depositions from them saying, well, it has to be Joseph's child because we saw Elizabeth and Joseph in the orchard at midnight. And it's just this back, forth, back, forth, back, forth. Elizabeth gives birth. Her midwife asks her consistently throughout the birth who the father of the child was. Elizabeth names Joseph. Joseph is then convicted. But it's a fascinating trial because there is so much evidence for Joseph to be the father. There's so much evidence for John to be the father. And because of all of the richness of those court documents and the unknowns of this trial, this is actually one that I have my students do as a mock trial, where the students get assigned different characters. We have an Elizabeth, we have a Joseph, we have a John, everyone else, and then a couple of students are assigned to be the justices, and they then have to weigh all the evidence and make their ruling on who they think the father of the child was. And the thing that strikes me, particularly with this one, is it's one of the few trials where I genuinely am not certain who the father of the child is. And perhaps Elizabeth didn't know. There's a lot of evidence she was having sex with John and with Joseph. Did Elizabeth just pick Joseph and stick with it throughout the birth?
I have to imagine that this was an exciting find for you because it's one of your ancestors, and although it's connected to a sexual misconduct case, there's so much evidence that you must have gotten a better feel for who your ancestor was.
He does not come off particularly well in this trial. There's one point in which he calls Elizabeth, and I quote, a devilish lying jade.
Now that we've looked at one of these sexual misconduct cases in great detail and have a feel for how the colonial New England court systems worked, we should go back to your original premise that over the 17th and 18th centuries, the legal systems in New England made the people in New England seem more English. Would you tell us how that worked and how you came to this conclusion?
A lot of this came from tracking the evolution of these trials. One of the things that is really noticeable with Rhode Island, which of course comes into existence because Roger Williams is banished from Massachusetts Bay for heresy. He goes off, he founds what will become the colony of Rhode Island. And he makes a conscious decision that Rhode Island's legal system will be founded on English law. And I think he's doing this for a couple of reasons. One, Roger Williams had cause to be extremely familiar with the workings of English law of that period. As a younger man, he'd served as a clerk to Edward Coke, who's probably the most famous justice and writer about law in England of the late 15 and early 1600s. And there are elements of English law today that are rooted in his books, particularly the Institutes of Laws. There's also evidence that his ideas about law influenced our Constitution eventually in the 1780s. And so because Williams had clerked for Coke, this had given him a very nuts and bolts understanding of how English law worked. I also think Williams is making a conscious decision. He is founding a colony which is always going to be opposition to Massachusetts. Massachusetts, a larger, much more powerful colony, but Massachusetts is a colony which is not loved by the English kings. And so by modeling his law on English law, he in turn can make an argument to the kings of England to keep renewing the Rhode Island Charter by saying, we are good, devout English subjects. Look at how our laws are modeled on English law. And as I mentioned earlier, Rhode Island is a colony which has attorneys from the beginning. And so you see that in the sexual misconduct law, the appearance of attorneys in the sexual misconduct law of Rhode Island for the duration of the time period I studied, 1650 to 1750. Massachusetts, by contrast, as I said earlier, thought attorneys were a very bad idea. However, Massachusetts goes through some massive political and legal change. In the 1680s, you have what's known as the Dominion of New England, when Massachusetts and the other New England colonies are put under direct English control. The Dominion of New England will be dissolved when William and Mary take the English throne in the late 1680s. Nevertheless, Massachusetts gets a second charter in 1692. Part of that second charter is a mandate that Massachusetts will now fall much closer in line with legal practices in England at that time period. One of those is the requirement that Massachusetts must now allow paid legal counsel. And so you have the emergence of attorneys in Massachusetts courtrooms over the course of the early 1700s. So this is an example of where you can see this immediate transition occurring with the colony that it was always closer to England, always having attorneys, the colony that broke away, and now, whether by choice, whether by coercion, is coming back, now including attorneys in their court system.
It seems like appearing to be English in your legal system was a form of self-preservation for the New England colonies. If they appeared to be English, the New Englanders hoped that the English crown would leave them alone so that they could do what they came to New England to do. Whereas if they allowed their legal systems to stray too far from English practices, the crown might actually start to meddle in their affairs.
I think that's a genuine concern. And if Maine got taken over by Massachusetts very early on, we have a few clues as to what would have happened in Maine. In the early 1640s, Thomas Gorges, who's a cousin of Ferdinando Gorges, who's the English man who really owns Maine at this particular point in time, is sent over to create laws and also a political system for Maine. And he writes a very extensive letter documenting his plan to have the laws of Maine, and here I quote him, steer as near as possible to the course of England. And again, the most important thing for any colony to survive is having a charter which is recognized by whoever happens to be on the throne in England. And charters need to be constantly renewed and renewed and renewed. So being able to demonstrate that, yes, you are acting in good faith, you are not pushing the boundaries too far, is important as much for your own political survival as anything else.
I'm glad you brought up the fact that Massachusetts didn't have lawyers, because it's a perfect transition into the time warp. This is a fun segment of the show where we ask you a hypothetical history question about what might have happened if something had occurred differently or if someone had acted differently.
The time warp. Historians can't predict the future, but they can speculate about what might have been.
Abby, in your opinion, what might have happened if Massachusetts had allowed professional lawyers to be involved in sexual misconduct suits during the early 17th century? Would the history of law and sexual misconduct in New England have turned out differently?
Well, one of the great benefits of having some New England colonies who allowed attorneys is it does allow us to do some hypothetical what-ifs. What would Massachusetts have looked like? And one of the things that I noticed with the sexual misconduct trials, which involve attorneys in Rhode Island in the course of the research for this book, but also I had found a couple of sexual misconduct trials involving attorneys in New Hampshire for my dissertation research, is that many of their legal defenses in these trials have less to do with whether or not their clients were actually guilty of the crimes they were being accused of, and more to do with efforts to pay attention very closely to the language being used. And there's a series of court trials in Rhode Island in which the lawyers' clients are actually getting acquitted on technicalities, in which the attorney is saying, well, this is the way you were supposed to conduct this trial under your law, under English law, and you didn't quite do it this way. And so they actually successfully use this as a defense a number of times. And now, over time, attorneys doing this, obviously, people are going to start paying attention. And Pennsylvania does eventually pass a law in which they say, if you're using legal technicalities as a defense, we're not going to let you do it. So I have to wonder if eventually the lawmakers of the colonies would have eventually begun passing those laws. But nevertheless, these court trials in Rhode Island, in New Hampshire, there's also one in Maine, which are very interested in the technicalities, are ones that also serve as a bit of a challenge to those justices who, as I mentioned earlier, are people who don't have formal training in the law. And so one of the things that many people have studied is the rising professionalization of the colonies, so that as you come into the mid-18th century, increasingly being a justice is not something that you can do simply because you happen to be the most wealthiest, most connected man around. Increasingly, it becomes something where it is expected that you will go to Harvard, you will go to Yale, you will actually study, you might even go to England and study. So I think the wider expanse of attorneys leads to a professionalization of all the legal trades across the board.
What aspect of history are you researching and writing about now? Are you staying in early America, or are you going to medieval Europe?
I am staying in early America. However, my next project, at first glance, appears to have nothing to do with this first book, because it's a comparative study of the various events of the Stamp Act crisis throughout British North America in 1765, and also the Regulator Rebellion in North Carolina in the late 1760s and early 1770s. However, my interests in the shifting role played by English law in the wider Anglo-American world and the lives of ordinary colonists are equally important in this project. So if rebellion and sex appear to have nothing to do with each other, the second project does feel, in some ways, to me at least, a bit like a sequel.
Well, as a scholar of the American Revolution, welcome to the field. I'm really excited about your project, and I can promise you that once you get sucked into the American Revolution, you will never leave.
I believe you.
This may be the start of many revolutionary processes.
I definitely believe you in that.
Where is the best place to look for more information about you, your work, and how we can get in contact with you?
Well, my email address at the University of Massachusetts Lowell is Abigail_Chandler@uml.edu. My history department has both a website and a Facebook page, and I often appear on both of those talking about what I'm doing, both in terms of my classes and also in terms of my research. And for people in the Boston area, there is also an organization called the Partnership of the Historic Bostons, who does many primary source document discussions in the Boston area, and you can nearly always find me at those.
Abby, thank you so much for this fascinating crash course study in early New English law.
You're quite welcome.
It is hard to imagine Massachusetts as a place without lawyers. The Commonwealth has produced so many great ones. James Otis, John Adams, John Quincy Adams, Joseph Story, Louis Brandeis, and that's just to name a few. And yet, during its early days, Massachusetts didn't allow lawyers to practice law. It may also be hard for us to imagine a world in which the law required an unwed mother to endure not just the terrible pain of childbirth, but the constant pleas of her midwife or minister to reveal the name of her child's father while she labored. It must not have been just an annoying experience, but a humiliating one. Today, single-parent households seem to be a normal part of society, and few would think to question an unwed birthing mother about the name of her child's father while she labors. Yet the vestiges of the early American past are still present in our modern legal system. Sexual misconduct cases still take place, and the burden of proof still falls largely on the prosecution. And just as in early America, women make up the majority of those who must prove that they are the victim of rape and other forms of sexual abuse. I don't normally editorialize on this show. I try hard to remain objective because it's professional, and I want to provide you with a place to form your own ideas and opinions. But I have to tell you, I don't think we are really all that far removed from the days when midwives badgered laboring mothers about the names of their child's father. When I looked up the statistics so I could say with confidence that women make up a majority of those who must prove that they are victims of rape and sexual abuse, I was horrified to find that just like in early America, a majority of modern-day rapes go unreported. Today, that figure stands near 68%. 68% of rapes go unreported. Why? Think about it. Victims bear the burden of proving that they are victims. This means that in front of a judge, lawyers, the defendant, a jury, and spectators, they must bear witness and relive the horrible crime committed against them. I'm at a loss to say how we should fix this system, but it seems broken to me. If you were the victim of a crime like rape, there ought to be a less humiliating way to get justice. I am not a victim of sexual abuse. Instead, I bring this information about abuse to your attention because something about reading the present-day statistics about this problem and then thinking about how 17th and 18th century Americans handled sexual misconduct cases made me feel like I should say something about the connections I see. If you have been sexually abused, you should know that you are not alone and that there are people and organizations that can help you. I will post links to several of those organizations on the show notes page for this episode, benfranklinsworld.com/069. The show notes is also where you'll find more information about Abby and her book, Law and Sexual Misconduct in New England. I realize that this interesting episode has a rather heavy ending, but I didn't think I could sit on the connections I see. Are there connections that you see between history and the present that trouble you? Let me know. Send an email to liz@benfranklinsworld.com, tweet me @LizCovart, or post a comment on the show notes page for this episode or in the listener community on Facebook.
And remember, never leave till tomorrow that which you can do today.